which is designed to prepare you for the conveyancing exam in September. I do hope you're going to make the most of it and put in the effort required to get through the exam. Certainly, Mareka and Olufefi and myself will do what we can, and we'll put in the effort to get things across to you, and hopefully it will be a successful course with a successful outcome. I'm Mike Gregory. I've been lecturing this course for the Law Society since 1996, and many of the students who attended the course in the early days, many of whom still keep in touch with me when they have a problem, are now successful conveyancers with lucrative practices. And it's my hope, therefore, that the same will apply to all of you, and you will, once qualified, make a successful career out of conveyancing. You know, of course, the rules and law applicable to conveyancing, and therefore the structure of the course, have changed over the years. And we're now providing the course online for only the second time. We did experience a few hiccups during the first online course earlier this year, but that was to be expected, seeing as we were breaking new ground with virtual lectures. And load shedding challenges notwithstanding, I'm confident things will go much smoother over the next few weeks. I'm going to kick off today with just generally an introduction to conveyancing, and just ease you into the course, and hand over to Mareka on Wednesday evening. And Mareka, I think, will delve into it in a more deeply, and we would take it from there. So before I commence with the introduction, I'm going to just hand you over to Mareka and to Nolofefe, let them introduce themselves, and they will be, as I say, taking over as well over the next couple of months.
Nolofefe.
Oh, thank you, Mike. I'm Nolofefe Samalenge. I'm an attorney and a conveyancer at the same time, in notary. I'm practicing here in Pretoria. I've worked for Deeds Office for 6 years. I hope you will enjoy the course, and we will do our best. It will be my first time lecturing online and this course, and I believe that if we put all our strength, we will be able to make it and to prepare our papers and to prepare you for exams, and you'll be ready for exams by the time we finish this course. As Mike have said, that other people that he lectured, they are still contacting him to ask questions here and there. We hope that you won't be afraid to do so, even with us. The course is not that difficult. Don't put it in your mind that it's a difficult course, because the minute you put that, it will be difficult for you to deal with it. It is a doable course, and it's our everyday life. When you look at the acts, it makes sense. There's a link of every document that Deeds Office will ask you for. There's a link. There is a reason why they are asking for those documents, so that we make sure there is no fraudulent transactions, and also to cover you as a conveyancer. So don't be afraid of this course. This course is very nice. You will enjoy it, I believe. Thank you, Marek.
Yes, I'm the junior, as you can hear. I haven't worked with the Deeds Office. I have been practicing for 21 years, 20 of those as a conveyancer, since 2011 as a notary. I love the law, so I talk a lot. Yes, please contact us. Those of you who, I am Mareka Prinsloo. I forgot to say that. So you would have received yesterday already a first email from me with the guidelines to what you need to use when you prepare for every lecture, and when you prepare for the exams. You also got a couple of examples, and I also sent you the manual. One of the other things that you have to remember is to use your oh, sorry, it's not showing. Oh, there it is. Your legislation bundle. that you get from LEAD. And then you also will get other books that you go into the exam for. You have to have at least at all times with you your Deeds Registry Act and the Deeds Registry regulations. Please be interactive. It's very difficult for us not to see you, so be interactive. Pop questions and things into the comment sections. We can see them. We can answer you. We can stop when we can see there's something that you want to ask. So please be interactive. You only have 20 sessions, so make the most of it. And we will stay online as long as possible and make sure that we also assist you with any questions you email us. There's a lot of examples, lots of resources. Please use eLeader. Go on to eLeader, the second one, for the second intake. You are monitored how long you spend there. So if you spend enough time there, you will find the benefit. And there's just one more thing. There is a pre-assessment. We have to find out where exactly and what you know already so that we can assist you best. 25 questions. That is going out this afternoon after the first lecture. You have until Tuesday to submit those back. So if you have questions on that, don't ask them during the lecture about that. Mail me. You all have my email address now because you all have received emails. And that's me. Energy in a bottle. Let's go. I've got a 10 o'clock client coming in for an anti-nuptial contract.
Thanks, Marika. As you guys can hear, Marika is more the millennial than I am, and she will be driving this course. And hopefully you'll all, as she says, interact and make the most of it. All right, guys. So I'll then just kick off, say goodbye to Marika. Nolefefe, you're going to hang on and stay on the course as long as you wish. The rest of you guys, hopefully you'll have your pens and papers ready, and you'll focus on what we have to say. The lecture is being recorded. I understand. So those of you who have load shedding or can't get onto it will always be able to get back to it at a later stage. All right. So hopefully you'll have got your course material from LEAD, from which you'll notice the course is broken down into about 20 chapters or modules. Have a look at the course breakdown and you'll see the journey you're going to be taking over the next 2.5 months. You know, over the years, I've been lecturing, and as Nolefefe says, it's occurred to me that the perception that the conveyancing exam is a difficult one is just that. It's a perception. And despite the historical very low pass rate, I'm convinced that if you're prepared to do the work, you ought to be able to pass the exam without difficulty. I've always maintained that the exam is not a difficult one. And really, as we say, it'll be easy to pass if you put in the work. You know, and of course, there's a lot of ground to cover, and it does require time management and the ability to memorize forms, as one part of the exam is essentially a drafting one, where you'll be required to draft the deeds and documents that are lodged for examination at the deeds office. So the ability to memorize documents will stand you in good stead. Of course, also working in a conveyancing department and getting practical experience will be an added advantage. And this we will see from the pre-assessment, how many of you do have access to a conveyancing department. I mean, when I wrote the conveyancing exam in 1982, there were no courses like this. And I remember as an article clerk, learning a lot from the conveyancing paralegals at my firm, and even taking my dictaphone to the deeds office and recording the various deeds and applications that were filed at the deeds office so that I could memorize them for the exam. Nowadays, you'll receive a booklet in the exam containing all the prescribed forms in the Deeds Registries Act and the Sectional Titles Act for you to refer to. There'll be a further discussion and time devoted to exam preparation towards the end of the course. Okay, so as I said, the course will consist of some 20 lectures, more or less depending on how quickly or slowly we get through the 20-odd chapters or modules. There'll be some time devoted at the end for exam preparation, because as I've said, the aim of the course is to prepare you so that you have a greater chance of getting through that conveyancing exam. A lot of the forms and documents that you may be required to draft are, as I said, prescribed in the regulations to the Deeds Registries Act and the Sectional Titles Act, and these are made available to you, but many of the documents are not prescribed. For example, powers of attorney to transfer and numerous applications that we will be discussing with you. And I think you'd do well to memorize the wording of these applications. Of course, we'll deal with this as we go through. We will, of course, also devote quite a bit of time going through past exam papers as part of your exam preparation. There will be some assignments that you will be required to do and feed them back to us so that we can see how you are getting on, that the exam, that the course is actually getting through to you. And essentially, the conveyancing exam consists of 2 papers. The first paper is 2 hours long and is mainly based on sections and or regulations to the relevant acts forming part of the syllabus. You'll get a copy of the syllabus. The second paper is 4 hours long because it requires you to draft the numerous applications and documents in the prescribed manner. So just on that point, whilst you are now getting the prescribed forms made available to you in the exam, for example, if you're asked a question to draw a deed of transfer, there's a form E, which is the prescribed form for a deed of transfer. All you need to do is flip to that form and fill in the relevant detail from your exam question. Nevertheless, it's a 4-hour paper. You're going to be wanting every minute of that 4 hours. So where you can memorize the prescribed forms rather than have to search for them in your booklet and copy them from your booklet, you're going to waste a lot of time if you have to do that. Okay, so apart from exam preparation, of course, we also need to ensure that you understand what conveyancing is all about and what a conveyancer does. And from my experience, a lot of people, when they join this course, they do it because maybe they've got clients who will give them conveyancing work. Maybe they're under pressure from their law firms to qualify as conveyancers, even though they don't have a conveyancing practice. So it's important that you have the aptitude for conveyancing or property law. I know, for example, whenever you meet somebody for the first time, whether it's on the golf course or at a social function, you often ask the question, so what do you do? And when you say you are an attorney, the next question is going to be, oh, well, what area of law do you specialize in? And when you mention to them that you're a conveyancer, you can almost hear them thinking to themselves, oh, so you're not a real lawyer. Okay, there's even this misconception amongst members of the legal profession. When I was in big law firms, all my partners used to think, all you do is fill in forms which your secretary prepares, and you more than likely find in large firms that the conveyancing department is located next to the accounts department, mainly because it generates the most fees usually. And the perception amongst other lawyers in the firm is generally that a conveyancer is merely a quasi-lawyer whose only job is to sign off on prescribed and pre-printed forms, and as I said, whose presence in the firm is only tolerated because of the fees they write. Yet, nothing can be further from the truth. Yes, of course, we don't have the exciting and flamboyant careers that your litigation attorney enjoys. We don't get to brief counsel, sit in court and argue interesting cases, or fly overseas to interview witnesses. The furthest we get to travel is the deeds office. So yet if you look at the syllabus and what you will be expected to learn in order to pass this exam, you will see that you need to be conversant in all aspects of the law, including family law, divorces, for example, the administration of deceased estates, commercial law, the drafting of sale agreements and lease agreements, insolvency law, accounting. The list goes on and on. Just some of the acts that you will be required to have a thorough knowledge of include the Deeds Registries Act, of course, the Sectional Titles Act, the Alienation of Land Act, the Matrimonial Property Act, Trust Property Control Act, the Transfer Duty Act, Consumer. The list goes on, and we'll go through all of those bits of legislation, obviously, as part of the course. Bear in mind, you want to become conveyancers, but a conveyancing practice can also be very stressful. Remember, when you transfer a person's immovable property, you are dealing with his most valuable asset. The purchaser will be entrusting you with a purchase price that is more than he's ever spent before. The estate agent will want his commission sooner rather than later, and all these parties will be on your back for reasons why the transaction is taking so long. And if your transaction is rejected at the deeds office because of an error that you've made in the drafting of the document, you'll come in for even more flack. So I've always maintained that no attorney can consider himself or herself a well-rounded member of the legal profession unless they have at least attempted the conveyancing exam and have a basic understanding of conveyancing, which is why I don't really like the label conveyancer and prefer the more accurate title of property lawyer. We want to turn you guys into property lawyers. Conveyancers are attorneys who specialize in property law. You don't call a lawyer who specializes in labor law a laborer, okay? So the conveyancing is a term that's going to stay with us, but I want you to become property lawyers, because apart from just drawing up deeds and mortgage bonds and lodging them at the deeds office, there's going to be a lot more to property law. You'll be involved in the township developments, opening of sectional title schemes, registering servitudes. There's a lot more to just simply transferring property. So let's have a look. What does a conveyancer do, and what is conveyancing all about? Back in the day, when I was studying conveyancing, there was a book that was regarded as the Bible on the law of conveyancing by a fellow called Jones. Sadly, this book is Jones on Conveyancing. Sadly, this book's out of date now, but still has some relevance in explaining what conveyancing is all about. Jones defined a conveyancer as an attorney who has specialized in the preparation of deeds and documents which by law or custom are registrable in a deeds registry, and which you are permitted to do after practical examination and admission by the High Court. So he goes into a fairly lengthy definition of what a conveyancer does. In the Deeds Registries Act, of course, a conveyancer is defined as a person practicing as such in the Republic and includes a person admitted as an attorney. So you have to be admitted as an attorney before you can practice as a conveyancer. Up until the mid-1990s, a conveyancer was defined as a person practicing as such in the province in which he or she was admitted. Now, this, of course, limited the conveyancer's ability to deal with transactions involving property situated in other provinces. Deeds that had to be lodged for registration in a deeds office in another province would have to have been checked and prepped by a conveyancer admitted in that province. Nowadays, when you get admitted as a conveyancer, you will be entitled to practice as such throughout the Republic. So, again, let's examine, what does a conveyancer do? In previous courses where we were lecturing face to face, I'd often ask the question, what does a conveyancer do? And I'd get answers such as he transfers property, or he registers transfers and mortgage bonds. Well, of course, that's correct, but let's examine those answers in more detail. Yes, if you sell your property, you appoint a conveyancer to transfer the property. So what does a conveyancer transfer? He transfers ownership. Ownership in what? Ownership in specifically immovable property. Okay, so a conveyancer deals mainly with immovable property, not with movable property. That's more the domain of a notary public when you deal with registrations of assets, movable assets, registrations involving movable assets, you would go to a notary public. So a conveyancer is concerned mainly with immovable property, and he transfers ownership. Okay, what is ownership? Ownership is a real right, and we're going to distinguish between real rights and personal rights later on. But a real right, how is a real right created? It's created by a process of registration at the Deeds Office. The Deeds Registries Act will say that a real right is a right that becomes real upon registration. So a conveyancer deals with real rights in immovable property. Ownership is just one example of a real right. A mortgage bond is a real right. A servitude of right of way is a real right. So there are numerous real rights, and a conveyancer will deal not only with the transfer of ownership in immovable property, but he will deal with real rights generally, as I say, involved in immovable property. Let's break this down further. Real rights are created through a process of registration, and you will register at the Deeds Office. Okay. Looking at immovable property, it's purely immovable property or land. Okay. Immovable property can come in various forms: vacant land, farm property, an earth in a township, a unit in a sectional title scheme, an agricultural holding, and even a registered long lease is regarded as immovable property. And one thing you have to understand, in order for immovable property to exist, it has to have been measured and surveyed by a land surveyor and plotted on a diagram or a general plan, which is held in the office of the Surveyor General. Okay, so the diagram is the map drawn by a land surveyor, approved and recorded by the Surveyor General, and it reflects the boundaries and beacons and certain other aspects of the piece of land concerned. Okay, so when you're dealing with immovable property, unless it's been delineated or demarcated on a diagram or a general plan, it's not capable, it's not registrable or capable of being registered at the Deeds Office. Okay, a general plan, unlike a diagram, similar to a diagram, but it's drawn by a land surveyor when, for example, a property developer wishes to divide a large piece of land into smaller portions. If there are, say, 10 or more proposed portions of land, it will be cumbersome to draft a diagram for each portion. So rather than combine the diagrams onto one sheet of paper, which will then reflect all 10 or however many portions, a general plan is framed. And you can have a look at these examples later on. I'm not going to show you these examples just yet. I'll share those examples with you later, but we'll have a look at that in due course. I'm just wanting to ease you, as I say, into what conveyancing is all about. Now, let's have a look at real rights. Okay, we've looked at immovable property. It's got to be reflected on a diagram or a general plan. And a real right such as ownership, a mortgage bond, or a servitude. A real right is binding on third parties generally and binding on successors in title to that immovable property. Different to a personal right. If you have two properties adjoining one another, let's say property A, owned by property A, and a property owned by B. The only way that A can get onto his property is to go over B's property and traverse B's property. So A and B enter into an agreement that says, that allows A to access his property over B's property, and that agreement contains certain conditions. For example, A will maintain the right of access, B will refrain from planting trees or obstacles on that right of access, and A will then be able to access his property. That is an agreement that is binding inter partes between A and B. And A can enforce his rights against B, etc. If B were to sell that property to C, C would not be bound by that agreement because he was not a party to it, and he can then deprive A of access to that to his property, notwithstanding that there may have been an agreement in perpetuity between A and B. In order to make that right binding against C, you would have to register that agreement at the deeds office by way of a deed of servitude, a notarial deed of servitude of right of way. That's what that's the essential difference between a real right and a personal right. Personal right binding inter partes, real rights registered at the deeds office are binding on third parties and successors in title. Okay, so turning now to registration in the deeds registry. Registration takes place when documentation drawn up in the prescribed or acceptable manner by a conveyancer is lodged for examination at the relevant deeds registry or deeds office. And once registered, the real right, whether it is ownership or a mortgage bond or a servitude, is created. Okay, just talking a little bit about registration at the deeds office. I think South Africa has one of the best land registration systems in the world. When I practiced in the UK as a solicitor for a number of years, I realized that their land registration system, although similar in some respects, is very antiquated. In certain instances, and this is true in other countries as well, owners are well advised to take out title insurance to insure against their ownership in the property being contested. That's not the case in South Africa. Furthermore, in the UK, both the seller and the purchaser must appoint a solicitor when they are involved in a property transaction involving the transfer of immovable property. In South Africa, it's the seller who appoints the conveyancer to attend to the transfer of his property, notwithstanding the fact that it's the purchaser who pays the costs. And we'll talk more about this process in more detail. Yeah, of course, our land registration system is not perfect. Any of you who may have purchased an immovable property will know that it's an expensive exercise. It can take a long time, 2 to 3 months for registration to go through, maybe even longer now with COVID and the deeds office closing from time to time because of infections and what have you. But nevertheless, one is almost always able to ascertain who the owner of a specified piece of land is by a quick online deeds registry search. Okay, there are 11 deeds registries in South Africa. Pretoria and Johannesburg service Gauteng. You've got Cape Town, Pietermaritzburg for KZN, Bloemfontein, King Williamstown, Umtata, Kimberley, Vryburg, Limpopo, and Mpumalanga, which is Nelspruit, which is a fairly new deeds office. A lot of the deeds that were filed in Pretoria were moved over to Mpumalanga some years ago. Okay, now there are practices in the deeds office that differ from province to province. Nolufefi and I practice in Gauteng, so we will follow the rules that are imposed by the Registrar of Deeds, or the Chief Registrar who sits in Pretoria, and the Registrar of Deeds in Johannesburg, and we follow their requirements for registration. Olufefe, having practiced at the deeds office, will be able to give you more information on this and deeds office procedure, etc. So I'm going to let her deal with all of that in due course. Cape Town have slightly different ways of describing property and conditions. In KZN, funnily enough, when I returned from the UK, I practiced in Durban for a number of years, and I lectured the conveyancing course with John Christie in KZN. So some of you, obviously a lot of you are from KZN, a lot of you will be from Cape Town, a lot of you from the Free State maybe. When we lectured before going online, it was simply to students in Gauteng who were writing the exam in Gauteng. So this is the first time we are lecturing to students from other provinces, and just bear in mind when we come to look at the various forms and documents, follow the deeds office practice in your particular province. The exam is a national exam. You don't have an exam for students in Gauteng or the Cape or KZN or Free State. So you'll just have to adapt your document to the rules and regulations that apply in your particular province. So deeds office procedure, deeds office personnel, I'm going to hand over to Nolofefe when she takes on a course, and she'll be able to discuss this in more detail later. Okay. You've got to know quite a number of concepts, terminology, etc. for conveyancing. And I just want to go through some of those with you briefly so that you'll get to become familiar with them as the course progresses. So for example, transferor and transferee, you'll come across these terms. Who is the transferor? The transferor, usually but not necessarily, is the owner of the immovable property. Usually, as you can think about the seller who sells his immovable property, he is transferring it, so we refer to him as the transferor. And then, of course, the transferee is the person taking transfer of the property, usually the purchaser. Well, would always be the purchaser, or not necessarily the purchaser. He may have inherited the property. And the transferor is not always the seller or the registered owner. For example, the owner may be deceased, and it is the executor who is the transferor, transferring the property pursuant to the terms of the deceased's will. So the transferor is the person who has instructed the conveyancer to transfer the property out of the owner's estate, and the transferee is the person taking transfer. Just remember the difference between transferor and transferee. Then you've got mortgagor and mortgagee. Now, these terms are often confused. I can't tell you how many times, and I think a question has even arisen in the exam, who is the mortgagor and who is the mortgagee? And a lot of people say the mortgagor is the bank who lends the money, which is not correct. The mortgagor is the debtor who has borrowed the money, who's borrowed money from the mortgagee, who is the creditor. He borrows the money from the mortgagee to finance the purchase of an immovable property, for example, and that debt is secured by the registration of a mortgage bond, or sometimes called a deed of hypothecation. Okay, same thing as a mortgage bond. In the UK, I used to refer to a bond. I need to apply for a bond over my property, and a bond in the UK is something completely different. There they call them mortgages, which is probably the more correct term. I have a mortgage on my property. I don't have a bond on my property in the UK. A bond is something like a charge. It's completely different. But when we refer to a bond, we know in South Africa we're referring to a mortgage bond. Okay. Grantor and grantee. This is terms that you come across when you deal with servitudes. Now, we're going to be talking about servitudes, pradial and personal servitudes. The person granting the real right or the servitude. In other words, I'm giving you a servitude of right of way over my property. I'm the grantor. I'm getting a bit of feedback from G. Is there a reason why that is the case? Okay, thanks. So the grantor is the person granting the real right, and the grantee is the person benefiting or receiving the real right, and that's we deal with when we deal with servitudes. Now, servitudes, being real rights, are created by registration. They are normally created by a notarial deed, and that's not part of this course. So you won't be required as part of this course to draft a notarial deed of servitude of right of way or usufruct or whatever, but you will need to understand what a servitude is, whether it's a personal or a pradial servitude, and sometimes it is capable of being created without a notarial deed, and we'll discuss that in more detail as we go along. So grantor and grantee, I'll talk about a title deed. A title deed is a document registered at the deeds office proving ownership. Your deed of transfer, prescribed Form E, is a title deed. So your title deed is the document that is registered at the deeds office and issued to you, showing that you are the registered owner of the property described in that title deed. A title deed can also take the form of, as we'll see, a certificate of registered title or a certificate of consolidated title. So a deed of transfer, all deeds of transfer are title deeds, but not all title deeds are deeds of transfer, if that makes sense. You'll see when we come to dealing with consolidations and subdivisions, when you want to subdivide a property into 2 or more portions, you will apply for and be issued with a certificate of registered title showing that you are now the owner of that subdivided portion. That certificate of registered title, which is issued to you and registered in your name, is a title deed. Similarly, if there are 2 adjoining properties that you want to consolidate into one property, you can do this by way of applying for a certificate of consolidated title, and that certificate of consolidated title is a title deed. It shows that you are the registered owner. We'll deal with consolidations and subdivisions in due course. Of course, when you subdivide a property into 2 portions, you've got portion 1 and the remaining extent, okay? You need to have, for that portion 1, you're creating a new entity of land for the very first time. And what did we say when you have an entity of land or a piece of land? For it to be registrable, it must be demarcated on a diagram. So you will have a subdivisional diagram framed by a land surveyor, proved by the Surveyor General, that shows you are the owner of that portion. So, sorry, yeah, there's a question. Explain again why not all deeds, title deeds, are deeds of transfer. Well, as I said, all deeds of transfer are title deeds. Okay, if you've got a deed of transfer that shows that you purchased property and it's registered in your name, it's a title deed. So you would say, my title deed is filed in my safe. Okay, it's a deed of transfer. But you may have subdivided your property and applied for the issue to you of a certificate of registered title. A certificate of registered title is not a title deed, is not a deed of transfer. There's a prescribed form for a deed of transfer, Form E, and there are prescribed forms for a certificate of registered title and a certificate of consolidated title, Form O, I think it is. We'll come to those prescribed forms, and those certificates are also title deeds. So a title deed is just a general term to show for the document that is evidence that you own that particular property. And a title deed can take the form of a deed of transfer, a certificate of consolidated title, or a certificate of registered title. Don't worry too much about that. It'll become clearer when we deal with those specific deeds and documents. Okay. All right, diagrams and general plans, we've already discussed that, but we will also be talking about a servitude diagram, a subdivisional diagram, a consolidation diagram. These are diagrams that have to be framed to show areas of land that will require a registration at the deeds office. Okay, you'll come across a subdivisional diagram when property is subdivided into 2 or more portions, as I've said, and a consolidation diagram when 2 adjoining properties are consolidated into 1 stand. A servitude diagram will be a diagram indicating the servitude area over a piece of land, and more about that we will talk as the course goes on. Okay, we're just talking about the various concepts and terminology that you're going to be encountering in this course. Freehold property, leasehold property. Freehold property is an absolute ownership of an earth in a township or a farm. If you own property, be it a farm, agricultural holding, or an earth in a township, even a sectional title unit, not sectional title, that's freehold, or you own a sectional title unit. And sectional titles will be dealt with later by Mareka, who's an expert on sectional titles. So she'll be taking you on the course on the Sectional Titles Act and dealing with sectional title. You also have leasehold, 99-year leasehold in this country, which is basically being phased out. But you can still have a registered long lease over immovable property, and that's a leasehold property, which is also counted as immovable property. You can still have leasehold rights as opposed to freehold rights, where the owner retains ownership of the property, but it's let to you over a long period of time. I mean, in the UK, I owned an apartment on 75-year lease. It was a 75-year leasehold. Lots of properties in the UK are owned under leasehold as opposed to freehold. So real rights and personal rights, we've already discussed the distinction between a real right and a personal right. So hopefully you understand the distinction. Real rights are binding against third parties and successors in title. Personal rights are binding inter partes. Once a personal right is registered, it's a servitude. So we've got to talk about personal servitudes and predial servitudes. There's 2 types of servitudes. A predial servitude is a right, for example, the right of way granted over a property, which will be the servient tenement, and it's in favor of another property, which is the dominant tenement. So when you deal with a predial servitude, you have 2 properties. The servient tenement, we call it the servient tenement, which is subject to the right of way, and the dominant tenement, which is the property that is entitled to the right of way. And I'm using the right of way as an example of a predial servitude. Okay, there can be other examples of a predial servitude. So the owner of the servient tenement, the property that is subject to the servitude of right of way, is the grantor of the servitude. He is granting to the grantee the right, a servitude of right of way over his property, and his property will then be subject to the servitude of right of way. So the servient tenement is subject to the servitude of right of way. The dominant tenement is entitled to the servitude of right of way. This will all become relevant from a drafting point of view, guys, when you are required to draft a servitude condition in a deed of transfer, for example. Okay, and we'll again be coming to this later on in the course in one of the chapters. So don't worry too much about that, but just at this point in time, try and understand the difference between a servient and a dominant tenement, a predial and a personal servitude. These are just concepts that you will encounter in the course. Okay, again, those are those. There's others that you'll come across. Nolifefe, who's the deeds office She'll talk all about the terms that you come across in the deeds office procedure, such as when you lodge documents at the deeds office, when they come up on prep, after they've been examined, when they get registered, or when they get rejected, when you need to black book, symbols, when you lodge a batch of symbols. Okay, you'll get familiar with lodging a batch of symbols, arranging lodgement, the notes that are raised by an examiner. Can you have the document restored, expedited for examination? When do you execute, endorse? Linking all of these terms, deeds office terms, you'll become very familiar with by the end of this course, so that you know what it all amounts to. I don't want to go into too much detail at this stage. You'll see, and this will all become familiar. So then there are terms of subdivision, apportion, remaining extent. Mareka is going to analyze Form E, the deed of transfer, with you when she takes over on Wednesday. And one of the things she will talk about, obviously, is the property description, which will be an earth or a farm or an agricultural holding or a sectional title unit. And if you subdivide the property, you will subdivide it into two portions. The subdivided portion will be portion 1 of the earth, and the remaining portion will be called remaining extent. I don't want to go into property descriptions at this point in time, but you will learn about those in due course. Okay, so how are we doing on concentration? I see we're about 9:30. I think we've been going for about half an hour. If I want to break every now and again so that we don't disrupt concentration, usually after every 20 minutes or so of me whittering on, you guys are going to lose concentration, and I think it's a good idea. Maybe every half hour we have a bit of a break, 5-minute break, no more, no less. Put the kettle on, get a cup of coffee or something like that, and then take it from there. So we're at 9:30. We're not going to go through to 1 o'clock, by the way, guys. Okay, I know this lecture is scheduled to go from 9 o'clock to 1 o'clock. I never run to 1 o'clock. I think it's just too long. So let's just have a quick 5-minute break, and I'll come back, and then we'll see, we'll continue with this basic introduction. I'm just easing you guys in. Please believe me, when Mareka takes over on Wednesday, you guys are going to have taken your Ritalin or your Concerta and have a Red Bull handy, because you'll need to focus. All right, guys, see you in 5 minutes, 9:35 on my computer clock. Thanks. Okay, guys, it was a quick 5 minutes. Hopefully that's long enough for you to have a bit of a break and just refocus. And hopefully what I've discussed up until now has made sense or is making sense, and hopefully will assist you in understanding what conveyancing is all about. For those of you who've had no access to a conveyancing department, or who are doing conveyancing for the very first time, you may feel a little intimidated by all these terms. Don't worry too much about that. It's early days yet. One of my associates that works with me now was one of my students some years ago. He had never had any access to a conveyancing department, didn't know what conveyancing was all about, and yet he passed with 78%. And he asked me then to mentor him once he had qualified. And although I handle most of his conveyancing matters, he's learnt a lot. And I think once you qualify as a conveyancer, that's when your learning about property law and your experience on property law really starts to kick in. You'll really only become experienced property lawyers once you've qualified. Okay, the purpose of this course really is, let's get you through the exam, let's get you qualified, and then you can start delving into conveyancing. Okay, I have a number of students from previous courses who consult with me and say, how do I do this? And we are here to help you once you've become qualified. Please take my email address, take my contact details, and feel free to contact me at any time. I get almost on a daily basis students contacting me saying, please help me with this servitude. I'm having a meeting on Tuesday with a conveyancing student of mine from about 10 years ago who wants to consult with me on a matter, and it's rewarding for me to be able to help conveyances. And you never stop learning. I still have deeds that are rejected at the deeds office, and I still learn a lot from conveyancing, although I'm due to retire now, and that's why I'm handing over to the Marekas and the Nolufefis of the world. Okay, my contact details, by the way, my email address. In the past, what's been happening, I know, listen, I'm not a millennial. Mareka's got this e-leader platform where all the examples are going to be on. I can share documents with you. I've got to become familiar with it, but rather email me if you need any examples or assistance or have any queries. It's Mike, M-I-K-E, Mike at hglaw.co.za. And my cell phone number, I think we've got a WhatsApp group going, or it will be, I'm not sure. Mareka had a WhatsApp group going at some stages, 083 950 9070. There are my contact details. Feel free to contact me outside of the course, and I'll help you as much as I can. But in most instances, I think the lectures are going to be Mareka and Nolufefe. I'm just going to be a backup on matters. So I'm just giving you an introduction. Okay. All right, so hopefully now you've got some of the terminology of conveyancing. You understand what a conveyancer does. He deals with real rights in immovable property, real rights being created by a process of registration through the deeds office. Deeds office personnel, the chief registrar in Pretoria outranks the registrar in Johannesburg. You've got junior and senior examiners. I'd like to have a discussion with Nolufefe, because as an article clerk and a junior conveyancer, I used to go to the deeds office in Pritchard Street in Johannesburg. This is now going back to the 1980s. Many of you weren't even born then. And Rassie Erasmus was the registrar in Johannesburg, and I used to get to know all the junior examiners and the senior examiners, and I would even take them a bottle of whiskey occasionally. And if I had a matter that was urgent, I'd ask Rassie to have it expedited. I don't know if we can do that now. Or restored if it was rejected. Okay, so I used to get to know the deeds office quite well. I'm not sure. I don't go to the deeds office now I have somebody who does my registrations for me, but as preparation for this exam, it will be a good idea if some of you can actually go to the deeds office. Have a visit to the deeds office if you haven't already done so, just to see how the deeds office operates and the procedure there. I think it would stand you in good stead. And again, Nolufefi, being the deeds office, having worked at the deeds office, will be able to explain more to you about that. I had a question pop up, explain the difference between the various diagrams. So let's just deal with that quickly before we go on to the next topic. Immovable property, in order for it to exist and be capable of registration, has to be delineated on a diagram or a general plan. So you would normally have a diagram showing you the earth in the township, okay, or a general plan that will show you all the urban in a particular township. That describes the extent of the property. So you'll see that you have a property, for example, Earth 102 Johannesburg Township. That will be a stand, a piece of land in a township called Johannesburg, and it will say measure 1,000 square meters as indicated on the diagram or the general plan. So the diagram is just there. It's framed by a qualified land surveyor. It has to be approved by the Surveyor General. It's lodged at the office of the Surveyor General and at the deeds office. And once that diagram has been lodged at the deeds office, that entity of land is capable of being registered as a piece of land. So you have an earth in a township, let's call it Earth 102 Johannesburg Township, and it's a big stand, and the owner decides he wants to cut it in two, subdivide it, and sell off a portion of that piece of land. It can be done. Okay, he appoints a land surveyor to come onto site. He frames a subdivisional diagram showing portion 1 that's been subdivided now, that measures 500 square meters, and the remaining extent, which measures 500 square meters. Of course, he can subdivide it into 4 portions if he wants. Portion 1, portion 2, portion 3, and the 4th portion, which will always be called the remainder or remaining extent, measuring 250 square meters. Those portions are delineated or demarcated or framed, if you want to call it, on a subdivisional diagram because the property's been subdivided. Now, if you subdivide a property into 2 portions and the remainder needs to have access over the portion that's been created, you're going to want to register a servitude of right of way over portion 1 in favor of the remainder, okay, the dominant tenement and the servient tenement, and that might require a servitude diagram, a diagram framed by a land surveyor showing the area of the servitude. In order to create that real right, that servitude, you're going to have have a diagram showing the servitude area. Okay, so that's a servitude diagram. Then if you've got 2 adjoining properties, you own 2 properties, Earth 102 and Earth 103, and you want to consolidate those 2 urban into one big property so that, for example, you can build a property over the boundary line, then you get a land surveyor to come on site and frame a consolidation diagram showing now the new earth, which will be called not 104, because there's probably already an earth 104, it will be earth 123, for example. Okay, it gets given a new earth number and it's delineated on a consolidation diagram. Okay, so those are the types of diagrams that you will encounter. And the general plan. Let me see if I can give you an example. I'm experimenting, so if I lose you or you lose me, please bear with me. But let's just try this while we're working on this thing about sharing. Mareka knows it very well, Nolufefe probably as well. I'm going to try and share for the first time. Bear with me. Boom. Notes on conveyancing examples. certificate of consolidated. There's a consolidation diagram. Can you all see that? It's a consolidation diagram. It's approved by the Surveyor General, and it shows you the two urban that have been consolidated into property. Nope. Oh, sorry. Cannot see. Okay. All right. Okay. Oh, hold on. Let me see if I hold on, guys. I'm trying to put it across there. Okay. Sorry, guys, bear with me. I'm coming back to you now. Okay, I'll work it out and I'll send you examples. Well, you'll get it on eLeader, the subdivisional diagram, the consolidation diagram, and the servitude diagrams will all be available to you on your eLeader platform. Okay, so apologies for that, but you'll see examples of those diagrams. You don't have to worry too much about those. They're framed by the land surveyor. Okay. All right, sorry guys, I know you can't see those diagrams or the general plans. My bad, because I've got to get myself up to speed. I was supposed to be trained on this, but you know, I prefer to lecture face to face. But anyway, let's see how we get on. Okay, now, once you've got those concepts in place, the deeds, if you look at the breakdown of the course, and this is important, guys, if you want to prepare for this exam, learn the course breakdown. And I would even be so bold as to suggest that you memorize the course breakdown so that you know exactly where you are when you study. My focus on this, I think, is more for exam preparation. Mareka, I think, is going to be more teaching you the conveyancing, okay? But my focus here is to try and get you through the exam. Focus on the course breakdown. We're going to go through the Deeds Registries Act. We're going to deal with transfers of immovable property. Then we're going to go to mortgage bonds. Then we're going to go to disposal of mortgage bonds, how we cancel a mortgage bond, how we cede a mortgage bond. Then we're going to go to certificates of registered title. Yeah, I know. I'll get it right. Promise you guys, bear with me. Guys are telling me how to do this. I'll work it out. No worries. Anyway, then you're going to go to miscellaneous applications, estate transfers, transfer duty, VAT. All of that is part of the course, and there's a lot to cover. So I want to take you through a simple transfer of immovable property. I want to discuss with you the process that you as a conveyancer will follow when you transfer immovable property. This is starting off just very simply. Now, as you'll see, there are a number of reasons why property is transferred from one owner to the next. The most common reason is a sale by private treaty. You know, when you sell property privately or through an estate agent, between a seller and a purchaser. Other reasons include estate transfers arising from the death of an owner where the property is transferred in terms of the will of the deceased or under the law of intestate succession. So that's an estate transfer. I think Nolefefe wants to handle estate transfers in due course. That's a subject all on its own. A very common question that comes up in the exam deals with estate transfers. So you'll be learning a lot about estate transfers later on. Another reason, of course, for a transfer of immovable property is divorce. Couples get divorced, they have a divorce settlement agreement, and in terms of that settlement agreement, one of the spouses gets the property. Another reason for a transfer is a sale in execution, or a sale by public auction, or on insolvency, or rectification. If a transfer is transferred to somebody in error, you can do a rectification transfer, as we'll see, or an exchange transfer two property owners can exchange their property. So there are various causa for transferring property from one person to the other. But the most common one, of course, is where property is sold by private treaty. And I want to take you through that process, transfers under the Deeds Registries Act, following the rules and regulations that are set out in the Deeds Registries Act, and of course by the various registrars. The registrars can pass rules. They have a registrars conference once a year where they pass resolutions as to how they want deeds to be examined and prepared for their particular deeds office. Okay, and again, you'll come to that in more detail as well. Okay, so I want to take you through a transfer process where the property has been sold either privately or through an estate agent. But before we get into this, it's useful to understand the various role players in a property transaction, the typical transfer of immovable property. Some of you who are fortunate enough to own immovable property will have been through this process. You will have liaised or interacted or engaged with the conveyancer. You will have signed transfer documents, and you will know what it's like, what the conveyancing process is all about. But let's have a look at the various role players in a typical transfer transaction or transfer process. Okay, I like the analogy that conveyancing can be likened to a game. Okay, it's the object of the game is to transfer, is to register the transfer of ownership and to account to the various role players as necessary as quickly as possible. That's the object of the game. The game is to register the transfer, register ownership, pass ownership as quickly as possible, and account to the various role players in that particular transaction. Now, the rules of the game, if we use the analogy game, can be found in the Deeds Registries Act and the regulations, the Sectional Titles Act, and the other related bits of legislation relating to conveyancing. For example, the Alienation of Land Act, as well as registrar circulars, and to a certain extent court cases. Okay, so that's where you find the rules that you need to follow in order to get this registration through. So you need to follow those rules to ensure there's no rejections and no delays. Okay, there are about 11 or 12 players in this so-called game of registration, if I can use that term, in the team, depending on the type of transaction. And if one of those role players or team players does not provide an efficient service, is the weak link, then the whole process will be delayed. The whole transfer process will be delayed, and however well you did your transfer, if one of the role players, there will be a delay. So let's look at some of the role players. I think it's dealt with in your notes as well, but I just want to run through it very quickly so you've got an understanding. You've got the transferring attorney. We call him the transferring attorney, but obviously he has to be a conveyancer. He is the conveyancer that is appointed to attend to the transfer of ownership. Now, it's the seller's prerogative to appoint the conveyancer. Funny enough, when I lectured for a few years in KZN, I lectured at in Pietermaritzburg, and there was a lecture hall of about 70 students, and having come from Gauteng in the UK, I stood up and said it's the seller's prerogative to appoint the conveyancer to attend to the transfer. And some bright student at the back of the halls put up his hand and he said, no, in KZN, it's the purchaser's prerogative. And apparently he was quite correct. There's a case that goes back many years that says customary for the purchaser to appoint the conveyancer to attend to the transfer. I don't know how many of you in KZ are aware of this case, but it's not something that is published or shot. We don't shout it from the rooftops in KZN, because we want the seller to appoint the conveyancer to attend to the transfer. Of course, most sellers don't know conveyancers, and they rely on the estate agent to appoint the transferring attorney. So if some of you have an estate agent that's friendly with you and will refer work to you, that's one way of getting conveyancing work, by knowing an estate agent who will refer work to you, because estate agents can influence the seller as to where the transfer of his property must go to and who must deal with it. So you have the transferring attorney, and he plays a pivotal role in this whole transfer process. He is, if you want to call him, the captain of the team. If you think of the transfer as a project, then he is the project manager. He liaises with all the other role players in this whole transaction. He ensures the purchase price is collected. He makes payment for and behalf on all the various role players to ensure that the transfer is registered as quickly as possible. So he handles the purse strings. Okay, he'll collect the purchase price from the purchaser. He will pay the estate agent his commission. He'll collect the transfer fees from the purchaser, including the transfer duty. He'll pay the transfer duty over to SARS. He'll pay the rates and taxes to the local authority in order to get a rates clearance certificate. He'll pay the deeds office fee. If there is a bond that has to be cancelled simultaneously with the transfer, then he will settle the outstanding bond amount. He will pay the cancelling attorney his cancellation fees. So you'll see that he has a pivotal role in this whole process, and he drives the whole process. So without an efficient transfer attorney, you're going to run into big problems and inevitably delays. Okay, but we'll see what a transferring attorney has to do when we look at that whole process. Okay, just know that he's one of the role players, but he plays a pivotal role. Then you've got the estate agent. The estate agent is obviously the person who draws up the invariably the offer to purchase, which is accepted by the seller, and he refers the transaction to you for your attention, the transferring attorney. He has a role to play because he has to draw up the offer to purchase in a proper manner. He wants his agent's commission, of course, so he will be liaising with you. And yes, I think this lecture will be posted on eLeader, or it will be recorded. I'm just answering a question. Okay, great. The question's been answered. Sorry for that. So the estate agent has a role to play. He will send you the offer to purchase if there is an estate agent. He's not necessarily a role player if the property was sold privately without an estate agent, but you can regard him as one, because 9 times out of 10 you will sell your property through an estate agent. Then you've got the seller, who is the transferor. Obviously, he is a role player. He has to provide you with his FICA documents. The Financial Intelligence Centre Act is one of the acts that you will need to know about. It's part of the syllabus. That will be dealt with later. FICA, what do you call for? Remember, as a conveyancer, you will be an accountable institution. You'll have to FICA your client, so you'll have to get FICA from your seller. You'll have to get a copy of his rates account. You'll have to get his income tax number. You'll have to get information from the seller in order for you to proceed with this transaction. He's got to sign a power of attorney appointing you as the conveyancer. So he's got to sign transfer documents. He's got to pay his rates and taxes. And you'll see the various obligations on the seller in a property transaction. So he's an important role player. He's the transferor. Of course, then you've got the purchaser. He's an important role player. He's got to sign transfer documents. He's got to pay the purchase price. He's got to pay your transfer fees, including your transfer duty and the deeds office fee. etc. So if he doesn't do that, if he doesn't pay on time, or if he doesn't come in and sign his documents, and he's capable of delaying the transaction if he doesn't play his role. Then the purchaser's bank, 9 times out of 10, a purchaser is going to have to borrow money from a bank in order to pay for the purchase price. So he's got to get a bond. Okay, he's got to go in and sign bond documents, and we'll see that process when we deal with mortgage bonds later on in the course. Okay, so the purchaser's bank that's granting a bond, which will have to incidentally be lodged simultaneously with your transfer, they're a role player because they've got to instruct attorneys to attend to the registration of the mortgage bond. So there you have the bond attorney. The attorney or conveyancer that's been appointed by the bank to register the mortgage bond is an important role player. He's got to take instructions from the bank, draw bond documents, get the purchaser in to sign. The purchaser then becomes the mortgagor. He's got to sign the bond documents, got to pay the bond attorney his costs, and the bond attorney has to issue a guarantee to secure the purchase price or the balance of the purchase price. So clearly you can see the bond attorney has an important role to play in this whole transfer process. Of course, if the seller has an existing bond over the property that he has sold, that bond has to be cancelled simultaneously with the transfer. So you've got the seller's bank involved. They've got to issue cancellation figures. They've got to instruct an attorney to attend to the cancellation of that bond, and they've got to be paid their cancellation costs, which they'll get from the transferring attorney. So you've got your seller's bank, and you've got the bond cancelling attorney. And yes, the question, can a conveyancer become all of these? Yes, he can. When I was with big law firms, that are on the panels of all the banks, we would be the conveyancer for the seller, the transferring attorney, plus we would attend to the cancellation of the existing bond, plus we would register the new bond over the property in favor of the bank by the purchaser. So we would wear all our hats as the transferring attorney, the cancellation attorney, and the bond attorney. Nowadays, I think the banks are fairly reluctant to appoint the same attorney that's doing the transfer to register the bond because they consider there may be a slight conflict of interest. But yeah, when I headed up a property department for Rutledge Modise, I had 9 paralegals under me. There would be transfer paralegals who just did transfers. There would be a paralegal who just did cancellations. There would be a paralegal who just did bonds for Standard Bank. Then there would be a paralegal just doing bonds for Absa Bank. And so, yes, one firm can handle all of those transactions. Okay, so your bond cancelling attorney is a role player. Then, of course, you've got SARS as a role player. You'll see that they have to issue a transfer duty receipt, which is required for registration. The deeds office will not register the transfer unless they see a transfer duty receipt or exemption certificate issued by SARS, which they'll only issue, of course, if you've paid transfer duty. So the transferring attorney has to collect the transfer duty from the purchaser and pay it over to SARS. We do it by way of e-filing. We'll deal with transfer duty in more detail with Mareka. No, there's no capped amount for SARS. There, you'll see how transfer duty is calculated. Very important. Sorry, I'm not going to be lecturing you on transfer duty because it's a nice topic. There's a chapter on transfer duty, and there is a formula for calculating the transfer duty. From 0 to R1 million, there's no transfer duty payable. Okay, then from R1 million to, I think it's 1,750,000, it's 3%. Then from 1,750,000 to 2,250,000, it's 5%. There's a formula. Okay, you'll see it in your notes. It changes annually normally. So transfer duty is calculated, it's then paid to SARS. Of course, in certain instances, there's no transfer duty payable. As you'll see when we deal with the Transfer Duty Act, there's certain exemptions. One exemption being inheritance. So, yeah, no capped amount for SARS. An estate transfer, for example, where an heir inherits property from a deceased, there'll be no transfer duty payable. You'll have a look at Section 9 dealing with exemptions under the Transfer Duty Act. We're just dealing with the various role players at this point in time. Then you've got the local authority. They're a role player, and they often are a major cause for a delay of the transfer because it takes a long time to get rates figures and then to get a rates clearance certificate. Okay, we use a rates consultant to go to the local authority to get the figure and to get the rates clearance certificate. But of course, they are a role player. You collect the rates from the seller to get a rates clearance certificate that is valid for a period after registration. Then, of course, the deeds office, important role player. They examine the deeds and documents that are lodged for registration. The deeds office will want a fee for doing the examination. Okay, in my day, in the 80s, when I qualified as a conveyancer, the deeds office didn't charge a fee. But nowadays they do, and you have to collect that fee from the purchaser as part of your transfer fees and pay it over to the deeds office. Okay, they have a role to play because they examine the deeds and they will either reject it or register it. So you'll see all of these various role players. Those are the typical role players in a transaction. Of course, there are others. For example, if you're dealing with a deceased estate, an estate transfer, then the master of the High Court becomes a role player. If you're dealing with a sectional title unit, the body corporate or a homeowners association will become a role player as well. So those are the typical role players in a transaction involving the sale of immovable property. Okay, you'll become more familiar with them as we go through the process. Okay, so we've dealt with role players. Now I want to take you through a process of transferring, commencing the process. I want you to wear your hats as a newly qualified conveyancer. You're sitting in your office and a client comes to you and says, I've sold my immovable property and I'd like you to do the transfer. Let's have a look at the process that you as the transferring attorney will follow in order to get that transfer registered at the deeds office. Just the first step in getting that transfer process, commencing with that transfer process. You will be wearing your hat as a bond attorney later on as the attorney attending to the cancellation, and you will see that these transactions will have to be lodged simultaneously. So you will, as the transferring attorney, liaise with the attorney who's been instructed to cancel the existing bond, the seller's bond. You'll liaise with the bond attorney who's been instructed by the bank to register the bond, and these three transactions will be lodged simultaneously at the deeds office as a batch of three. So we'll talk about symbols and batches and lodging as we go on. Okay, we've gone for another half an hour, so it's 10:09. Let's have another quick break, put the kettle on, and we'll be back at, let's say, can we say we'll reconvene at 10:15 so that I can then take you through the next topic, which is the transfer process where you are acting as the transferring attorney in a property transaction where property has been sold by private treaty. Thanks, guys. I'll see you in 5. Okay, guys. Hopefully you're all back on board and we can carry on with the transfer process. Now that you know the role players in a typical transaction involving the sale of immovable property, let's discuss the transfer process in more detail. So when you're instructed to attend to a transfer of ownership in immovable property, the first thing you need before you can open your file and attend to the matter, of course, is the founding document giving rise to the transaction. So, for example, if you are attending to an estate transfer where the owner has died, you'll need to see a copy of the will to ascertain the beneficiary who will be the transferee. The will, in that instance, will be, I suppose, the founding document. If there's no will, you'll attend to the transfer under the law of intestate succession. We'll dealing with estate transfers later. If you're dealing with a divorce transfer, you'll need to see a copy of the divorce order and the divorce settlement agreement if there is one. So we'll examine the various causa in a transfer process in more detail later on. But as I've said, the most common causa or reason why ownership in immovable property is transferred from one person to another is because the property is sold, either by private treaty, either privately or through an estate agent. So let's examine this transaction first. The first and most important document you'll need, that is what I call the founding document, will be the offer to purchase or the sale agreement. Okay, now the offer to purchase is usually drawn up by the estate agent on his standard offer. It's signed by the purchaser, and if it's accepted by the seller, you then have a binding sale agreement. And as the transferring attorney, you would normally get your document, your founding document, that is the offer to purchase, from the estate agent with an instruction to commence the transfer process. You will then liaise with the seller and the purchaser and all the various role players in that transaction. So dealing with the founding document, the sale agreement, let's say you're sitting in your office as a newly admitted conveyancer and a client informs you that he's sold his property and he wants you to attend to the transfer. He has not used the services of an estate agent, so he needs you to draw up the sale agreement. Okay. Now, bearing in mind in terms of the Alienation of Land Act, which is an important act as part of the syllabus, no sale of land or alienation of land can be of any force or effect unless it's contained in a sale agreement or an offer to purchase, or as the Act says, a deed of alienation signed by the parties. So an agreement to sell immovable property must be embodied in a written agreement. Okay, you can a verbal agreement to buy and sell immovable property is not binding. Okay, so if there's no estate agent and you're acting for the seller, you need to take his instructions and get as much information as necessary to enable you to draw up the sale agreement. Okay, it is part of the syllabus, and there have been questions in the past involving the drafting of a sale agreement, not necessarily the whole agreement, but you may be asked questions on drafting certain clauses in a sale agreement. A sale agreement is obviously an important part of a conveyancer's function. So you will find as a conveyancer that not only do you have to draw up deeds and documents for lodgement at the deeds office, but you need to have some commercial expertise as well and draft the sale agreement for your client. Okay, so you'll need to take his instructions and get as much information as necessary to enable you to draw up the sale agreement. Now, what are the questions you will need to ask your client in order to get the information you need to enable you to draw the sale agreement? There's about half a dozen or so questions that I would ask my client to enable me to draw the sale agreement. Remember, you've got a precedent or a template of a draft sale agreement, but That's just a useful tool to enable you to draw the agreement. You've got to get the information from your client. So from my experience, the first question I would ask my client when he's in my office and I've got to draw up the sale agreement, the first question is what? Who is the seller? Now, that might sound obvious. I mean, the client sitting in your office is the seller, but that's not necessarily the case. You've got to ascertain, is he the registered owner of the property? For example, the property could be registered in his wife's name, but he regards it as his property because he pays the bond and the rates and taxes, what have you, and he says, I've sold my property. In actual fact, it's his wife's property. She's the registered owner. She will be the transferor. Or, for example, it's in his family trust, or he's registered a company and he's put the property in the name of his company. That is the registered owner. Therefore, that is the transferor. That is going to be the seller in your sale agreement. So the first thing you need to obtain from your client is the identity of the registered owner of the property that has been sold. Don't take for granted that he is the seller, that he is the registered owner simply because he says he has sold his property. So, and incidentally, all of this information that you will obtain from your client, you will need to verify by doing a deed search, and we'll come to that in due course as well. Okay, so once you've ascertained who is the seller, your next question, of course, is going to be who is the purchaser. Now, he might say, well, my next door neighbor, John Smith, has bought the property and he's purchasing it. Again, don't assume that he is the one who's going to be the transferee. You have to ascertain who is actually going to be taking transfer. John Smith, for example, may want to put the property into his wife's name, or they may be married in community of property, in which case it has to go into the joint estate of John and Mary Smith, for example, or he may want to put it into the into his family trust or a company that he has formed. Okay, so be careful to ascertain, in fact, who is the purchaser in the transaction. Just on this topic, when we deal with purchaser, he may decide he wants to form a company to take transfer of the property. In other words, the company has not yet been formed. So how would you describe a purchaser who doesn't want to take transfer of the property? He wants to put it into the name of a company which has not yet been formed. You will describe him in the deed of sale or your sale agreement as John Smith as trustee for a company to be formed. You know about pre-incorporation contracts in terms of the Companies Act. Sorry, sorry, Mr. Fayani, can you just turn off your video? Switch off your camera up at the top there.
I need to be
Okay. There's a little camera at the top there. If you switch it off, you can switch it off.
Yeah.
Or mute it as well, please. Mr. Fayani, can you please mute? Sorry, guys, let's just wait for Mr. Fayani to mute and switch off his camera. It might be disturbing everyone. I think he is rather confused. He's as bad as me with technology. Guys, I don't want to waste time, so can we please just continue? Unfortunately, I can't mute or cancel Mr. Fefeani's video from this end. Okay, great. So when you're dealing with a purchaser who wants to form a company that's not yet formed, you, in your sale agreement, you will describe him as purchaser as, let's say, for example, John Smith as trustee for a company to be formed. I would avoid using the word nominee because once you nominate someone, that can be regarded as a separate additional transaction, and you may be opening your client up to additional transfer duty, where SARS might think, well, once you've made the nomination, there's an additional transfer duty element to that transaction. So avoid the word nominee and just use as trustee for a company to be formed. Now, you may be asked a question on this in the exam. I think it has cropped up in the past. If that is the case, where you are selling to a purchaser or to a company that's not yet been formed, you have to take into consideration how you will protect the seller in this particular instance. In your sale agreement, you're going to have to draft an additional condition or clause dealing with the incorporation of that company. For example, it's got to be made a condition of the agreement that the company is formed within a certain period of time, a definitive period of time, and once formed, that it ratifies the contract. Now, this is dealing with Companies Act and pre-incorporation contracts. I think it's section 40 or somewhere about thereabouts, where a company can ratify a contract that was concluded for its benefit before it was incorporated. Okay, the same applies with closed corporations, but closed corporations are being phased out. So I don't think you can register closed corporations any longer. And there is a provision in the Closed Corporations Act that allows this to happen as well. So a company can ratify a contract concluded prior to its incorporation. So make the agreement subject to the company being formed and ratifying the contract. Okay, that's important. Another aspect is, of course, once the company is formed and it's ratified the contract, does that still protect the seller? You've got to go a step further, because if the company, once it's formed and it's ratified the contract, they then become the purchaser in that transaction. Now, remember, that company is an empty shell. It has no assets. It's got nothing other than the fact that it's been registered as a company. If the company doesn't pay the purchase price, doesn't come up with the guarantees to secure the purchase price or pay the transfer costs, and breaches the sale agreement, your client, the seller, is left with an action against the purchaser for damages. So who's he going to sue? He's going to sue the company. But the company has no assets. It's an empty shell. So how do you protect the seller? You make the purchaser or the signatory to that agreement, John Smith, stand surety for the obligations of the company. Okay, so that's very important when you're selling property to someone as trustee for a company to be formed, that you make the sale agreement subject to the incorporation of the company, and that it ratifies the agreement, and that the signatory binds himself as surety and co-principal debtor for the obligations of the company under that sale agreement. That's very important. And there's drafting. This is a typical sort of question that you may be asked in the exam. Draft the clause that you will insert in the sale agreement to protect your client, the seller, where the purchaser is forming a company for the purpose of taking transfer. Okay, so just bear that in mind. And again, have a look at the example on eLeader, and I can let you have examples as well, email them to you, of how we would describe the wording for that clause. You're not going to be asked a question in the exam to draft the whole sale agreement, but you may be asked certain questions on a sale agreement, because the sale agreement is an important aspect of conveyancing, of the transfer. You will encounter sale agreements all the time, and you've got to obviously apply your mind to each sale agreement. So that's dealing with who is the purchaser and what you would draft in your sale agreement. Now, what happens if the purchaser wants to transfer it to a trust? He wants to establish a trust and put it into a family trust, which has not yet been established. Well, there's no similar provision in the Trust Property Control Act. Okay, and that's another act in this legislation, in the syllabus, that you'll need to be aware of. So you cannot sell property to a trustee or a person as trustee for a trust to be formed. Okay, such a contract will be void ab initio, non-binding. It will be invalid. Okay, not binding at all. So avoid that. The trust has to be in existence, and letters of authority have to have been issued by the Master of the High Court to the trustees before they can purchase property in the name of a trust. So just be aware of that. Some agents have in the past presented me with an offer to purchase where the trust is the purchaser, but on further investigation, the trust has not been established as yet. That agreement is invalid. It's non-binding. So just bear that in mind. A company and a closed corporation can ratify a pre-incorporation contract, but the same does not apply for a trust, and it's the Trust Property Control Act. Don't know the reference offhand. The trust has to be in existence at the time of the transaction. Okay, so remember that. So those are the first two questions. Now, I said there are about half a dozen. Let's go through. What's the next question you'd ask your client? You've established who is the registered owner of the property, who you will describe as the seller in the sale agreement. You've established who is the purchaser. Next question I would think is the subject matter. What is being sold? Here you need to get the description of the property. Is it a farm property, an earth in a township, subdivided earth? Is it a sectional title unit? So establish the description of the property that is being sold. Now, he may not know the stand number or the earth number, so you'd maybe need to do a deed search just to check, get a proper description of the property that is being sold. Sometimes the question is asked, is the street address sufficient description of the property? Well, it's not ideal, but I would suggest that as long as you can establish the identity of the property from the way it's described in your sale agreement, then it is a valid and binding sale agreement. But I prefer to describe the property by reference to the earth number and give as much information as possible for the earth number, the extent, and even if possible, the title deed or deed of transfer number by which it is held by the seller. So ascertain what is being sold before you can draw up your sale agreement. These are obvious questions, obviously. The fourth question is just as obvious. What is the purchase price? What has he sold the property for? And how is it going to be paid? How is the purchase price going to be secured? If it's a cash sale, then you've got the purchase price payable in cash, but it's only going to be paid on registration of transfer. Yes, I'll share my email address at the end of the course, no problem. So establish, first of all, what is the purchase price? Let's say it's 2 million Rand. How is it going to be paid? Usually you will insist on a deposit just to bind the purchaser to the transaction. If there's no deposit, then the purchaser can walk away from the transaction at any time. So if you're acting in the best interests of the seller, always recommend to him that he negotiates a deposit. Rule of thumb, 10% of the purchase price or whatever, but at least some deposit is better than no deposit, which will be paid into your trust account pending registration of transfer, and the balance will be paid in cash on registration. Now, that will either come from a bond, a mortgage bond that the purchaser has to apply for, or he will be paying it in cash. If he's paying it in cash, usually it will be paid into your trust account, and you will hold it in a trust account pending registration of transfer. Now, let's just talk about this briefly as well. As a conveyancer, you will need to have a business account and a trust account. And as you know, and I'm sure this is all not news to you guys, is that money held in your trust account doesn't earn any interest because it's protected by the Fidelity Fund, the Legal Practice Council Fidelity Fund, so that if you as the conveyancer run off with the trust monies, the purchaser who paid that money into your trust account is protected. So he won't earn any interest on the trust account. If he wants interest, and bear in mind transfers take a while, they can take 2 to 3 months to be registered, to finalize, and if it's a substantial amount of money, the purchaser may want interest on his deposit or purchase price that he's paid into your trust account. Okay, you can, on his authority, and you'll need to get an authority to invest form signed by the purchaser, instructing you or authorizing you to invest that money in an interest-bearing trust account. Yes, Trust Property Control Act 57 of 1988. Thank you. So you cannot invest that money in an interest-bearing trust account without the purchaser's authority. Once he has signed that authority, then he must understand that whilst he's getting interest on that investment, he's not protected by the Law Society, who incidentally will take 5% of that interest in the trust account. So we'll go through this again in due course, but just remember, there's a huge financial responsibility on the transferring attorney. He's got to collect the purchase price, which is always a substantial amount. He's got to hold it in his trust account, and he's got to account to the seller on registration. The seller is not entitled to that purchase price prior to registration, but you have to have it secured in some form or another. The way you would secure the purchase price before registration is either by having the cash in your trust account, or you'll have a bank guarantee issued by the bond attorney who gets that guarantee from the bank. A banker's guarantee would suffice as security for the purchase price, payable on registration. A bank guarantee is as good as cash in your trust account. Okay, so again, the financial side of things, we'll at the end of this course, we'll deal with the statement of account and how we account to the various parties. So that's coming at a later stage. So once you know how the purchase price is going to be paid, let's assume there's a deposit. You will put in your sale agreement that that deposit will be held in an interest-bearing trust account for the benefit of the purchaser, pending registration. On registration, the deposit plus the balance of the purchase price will be paid to the seller, and the interest that's accrued on that deposit will be paid to the purchaser. And you, as the transferring attorney, remember, you handle the purse strings, you'll pay that deposit, the interest, sorry, on that deposit over to the purchaser when you account to him once the transaction has been finalized. Now, 9 times out of 10, the purchase price is going to have to come from a loan from the bank, secured by a mortgage bond. So in the majority of instances, the purchaser needs a bond, and you will need to make the agreement subject to the purchaser getting a bond within a certain period of time. That's called a suspensive condition. Okay, so you make the whole agreement suspensive upon the fulfillment of that condition, i.e. that he gets a mortgage bond within a certain period of time. You need to, as part of this exam, know the difference between a resolutive condition and a suspensive condition. Do You'll know the difference. A suspensive condition suspends the enforceability of the contract until it is fulfilled. So a suspensive condition will read along the lines, this agreement is subject to the suspensive condition that the purchaser will obtain a mortgage bond in the sum of R1.5 million within 30 days from the date of acceptance of this offer to purchase or sale agreement. Okay, if he doesn't get the bond within that 30-day period, then the sale falls through. It lapses and the parties can walk away without any obligation. Okay, the suspensive condition is not fulfilled, therefore the contract falls through. A resolutive condition, on the other hand, is a condition where on signature of the agreement is binding on the parties, but it will fall through and will lapse if the resolutive condition is not fulfilled. The conveyancer, there's a question, will the conveyancer be entitled to any share in the interest? Only if he's authorized in that authority to invest. If the purchase, he can say, by the way, there's a 1% admin fee for me investing it in an interest-bearing trust account, because that's an additional obligation on the conveyancer. So yes, I would say that the conveyancer is entitled to an admin fee for investing it in an interest-bearing trust account. So the answer to your question is yes, the conveyancer is entitled to a fee. Similarly, if the conveyancer gives an undertaking, sometimes the seller will say to the conveyancer, when my transfer is registered, please will you pay 50,000 Rand to X for a debt that I owe? And will you give him an undertaking that you are attending to the transfer of my property, and on registration you'll pay him the 50,000. So you can give an attorney's undertaking that on registration you'll pay that amount. That's another obligation on you that's not part of the transfer fees, and you can charge your client, the seller, a fee for giving that undertaking. We'll look at this in more detail when we deal with statements of account, and yes, I will provide examples of a resolutive and a suspensive condition. So an example of a resolutive condition, let's say I'm purchasing this property for my aged mother, let's say it's a retirement home, provided that if she dies within 3 months, the agreement will fall through and I'll get refunded all my money. Okay, because she's ill and she may not survive. The agreement is binding and it continues, but if within that 3-month period or whatever period you give, that event takes place, that cancels the agreement, then it resolves the agreement and the agreement is then falls through. Okay, I don't know if that's a very good example of a resolutive condition, but a resolutive condition, all you need to know is with the resolutive condition, the agreement is binding from day one, but if on the happening of that resolutive condition or event, it will fall through and lapse and be cancelled. It gets cancelled as opposed to falling through. Hopefully that's an example of a resolutive condition as opposed to a suspensive condition. Another example of a suspensive condition that you have in a sale agreement, and this is all, by the way, guys, you'll get this with experience over time. Okay, this will come to you. I mean, let's assume another suspensive condition is the purchaser has to get a bond to pay the purchase price, but also quite a common suspensive condition, he has to sell his house. He has to sell his existing property, okay, and get the proceeds from that sale to pay for this purchase, okay? So you'll have to make the agreement subject to the sale of the purchaser's property within a given period of time. Now, it may take a long time for that transfer to happen, the purchaser's sale of his property, okay? If you put a suspensive condition in your agreement that says this agreement is subject to the sale of the purchaser's property within 90 days for 1 million Rand, that suspensive condition says he must sell his property within 90 days, okay, for R1 million. Now let's assume the purchaser then sells his property after 2 months, 60 days, for R1 million. That, the minute he accepts an offer to purchase for R1 million for his property within that 90-day period, that fulfills the suspensive condition, and this sale agreement now becomes binding. Okay, you all with me? Now that sale agreement where he sold for R1 million, let's say, is subject to the purchaser getting a bond of 500,000 Rand to pay the purchase price. But that suspensive condition is not fulfilled, and as a result, the sale of the purchaser's property falls through because his purchaser didn't get the bond. The suspensive condition was not fulfilled. Does that mean this sale agreement falls through as well? The answer is no. So be very careful. The fact that he has accepted an offer to purchase that may be subject to a suspensive condition that was never fulfilled doesn't make this agreement lapse. This agreement becomes binding, and the purchaser will then be liable, and he will be in breach if he doesn't pay the purchase price. And the seller can then hold on to the deposit as a recoup or pre-estimate of damages, depending on how the sale has been drafted. And so you've got to be very careful when you are drafting the sale agreement, if it's subject to the sale of the purchaser's property. Make it subject to the successful sale of the purchaser's property, and make it clear in your drafting that this transaction is dependent on the successful outcome of the purchaser's sale. Okay, very important, and I'll send you an example of a sale agreement that has this suspensive condition. Okay, it might come up as a drafting exam in the question, for example, but it's useful in practice as well. So always be very careful when it's subject to the sale of the purchaser's existing property. And if it's a property that's going to, let's say, take 3 months to sell, I mean, the property market might be depressed, you may want to allow the seller to continue marketing his property, and if he gets a better offer or an unconditional offer within that time period, then the other sale will fall through. So again, bear that in mind. Okay, think about how you would protect the seller who wants to continue marketing his property. Okay. Bear all of that in mind when you're dealing with the suspensive condition. Know the difference between a suspensive and a resolutive condition, how the purchase price is going to be secured, etc. And we'll highlight the clauses in a sale agreement that you may get questioned in the exam. Of course, we're going to go through past papers and we're going to see the sort of questions that they answer. As I said, it's essentially a drafting exam. So paper 2, it used to be paper 1, I believe it's now paper 2, you will need to draft documents, clauses in a sale agreement, applications, etc. We'll take you through all of that, not to worry. Okay, so that's about 4 or 5 questions. The next question, I'm now getting enough information that I can take my template of a sale agreement and I can start filling it in with all the various details. Of course, there's others. No transaction is the same as the next. Okay, it's always you've always got to be very careful. Each transfer is different. So watch out with precedents and templates. And drafting, you need to know about drafting. You need to learn about drafting agreements, okay? It's an important part of conveyancing. When does the purchaser take occupation? Remember, we don't know when exactly transfer is going to take place. It takes on average 2 to 3 months. So, and the purchaser may want to move in at the beginning of July or the beginning of August. Okay, he wants to know so he can arrange his mover to move in on the 1st of August. Transfer will not have taken place by the 1st of August necessarily. So if you're going to stipulate in the offer to purchase or sale agreement that the purchaser takes occupation on the 1st of August, then you've got to stipulate for an occupational rent. Okay, he's occupying property that is still owned by the seller, therefore he must pay occupational rental to the seller. Rule of thumb, 1% of the purchase price, but obviously subject to negotiation. Okay, so establish when will occupation take place. Usually most estate agents will put in their offer to purchase that occupation will be given on transfer, which is fine. But if for any reason occupation is given earlier or later, the person in occupation, while it's registered in the name of the other person, must be asked to pay an occupational rent while they are in occupation of someone else's property. Okay, and then you'll ask about any other special conditions that might apply that you will put in your sale agreement. You're not going to make, you're going to say it's footstoots. If there's agent's commission payable, agent's commission incidentally is only payable on registration. In the past, an agent would claim his commission once the sale agreement became unconditional and the bond had been granted. That's no longer allowed. The agent must wait for registration before he gets his commission. And the same applies to you as an attorney, conveyancer. You can only take your fees once registration has taken place. Okay, you might be paid your fees up front. One of the nice things about conveyancing is that we don't have necessarily any bad debt, because we get our fees up front. We will not register a transfer unless we have our fees and the purchase price in our trust account. It's in our trust account. We really can only move it to our business account once we've effected registration. Let's say let's say you've got your transfer fees and you've taken those transfer fees, but for some reason the transfer falls through, for some valid reason, and you've now got to refund those fees back to the purchaser. And you no longer have it because you've taken it. So you've got to wait until registration before you take your fees out of your trust account, put it into your business account. Okay, I think when I used to get the day rebus, there was always this risk bulletin. And the Fidelity Fund, I think, pays out clients, conveyancing clients and RAF clients more than any other client. So it's not a very nice thing to say about conveyancers, but unfortunately there are conveyancers who have run off because you're dealing with such a large amount of money in your trust account. It's a temptation, I suppose, when you've got quite a lot of money in your trust account that you might want to run off with it, but please, I know none of you are going to do that. All right, so that's the sale agreement. Once you've got all of that information, you can draw up the sale agreement and you now have your founding document. Okay, once you've got that document, you can open your file and you can open your file, and the next step is to verify that information by doing a deed search. Okay, you must always carry out a deed search at the deeds office to verify the information, the registered owner, the ID number, his ID number, the IRF number, the title deed number, and whether there are any interdicts, the property might be attached, that sort of thing. Always verify with a deeds search. We'll talk more about this in due course. Now you've got your sale agreement. You've got your deed search that verifies everything. You've got, and now you can open your file. When you open your file, you've got those documents, and you can now start liaising with the parties, the various role players. You'll write to the seller, ask him for his ID document, proof of address, tax number, rates account, so that you can apply for a rates clearance certificate. If he's got a mortgage bond on the property, which you will be able to verify from your deed search, ask him for the bond account number so that you can write to the bank for the settlement figure and who they will be instructing to attend to the cancellation of the bond, and etc. And then ask him for his compliance certificates. That's another thing. in your sale agreement, invariably the seller must obtain an electrical compliance certificate, a gas compliance, or an electric fence compliance. You'll see this from a standard sale agreement that we will provide. Okay. You'll also then write to the purchaser asking him for his FICA documents, ID, proof of address, if it's a company, certificate of incorporation, certificate to commence business, etc. You need to know what documents you will call for in terms of the FICA Act, where you're dealing with a company or a trust or an individual. Okay, that's coming later on. You'll ask him for the deposit. If the sale agreement says he must pay the deposit, ask him to let you know when the bond has been granted, and anything else that comes out of your sale agreement. Okay, if there's an estate agent, you'll write to the estate agent, etc. So those are the initial letters that you will write. And if you want examples of these, we can provide you with them from a practical point of view, so that you can see what you do. Once you've got that, the next most important document you need is what? It's the title deed. Okay. Okay, that's a good question. Who's going to pay the costs of the sale agreement? Well, that's negotiable. Okay, it could be they'll share the costs. Usually the seller will pay for the costs of the sale agreement. He might want to say that the purchaser must pay those, but because he's not using an estate agent and he's not paying agent's commission, then perhaps he will pay for the costs of the sale agreement. We don't charge a big amount for the sale agreement. 1,000 Rand or maybe 1,500, it's up to you how complicated the sale agreement is. You will charge accordingly. So yeah, that's negotiable. Like anything is negotiable in your sale agreement. Very often the purchaser will negotiate with the seller that he uses his own conveyancer. Okay, we've had situations where the purchaser says, look, I'll buy your property, but I want my conveyancer to do the transfer because my conveyancer is a good friend of mine and he will give me a big discount on the tariff fee. Remember, the transfer fee is based on a tariff. The higher the purchase price, the higher your transfer fee is going to be. And a lot of attorneys, conveyancers these days have shot themselves in the foot because they so desperate for the conveyancing work that they'll agree to give any discount. Okay, I'm doing a transfer. Invariably, when I do a transfer, the first thing the purchaser says to me is, where's my discount? Okay, on the transfer fees. So that's also raises an interesting question as the conveyancer. Who is your client? You've got the instruction from the seller. Technically, he's your client. But you've also got to look after the interests of the purchaser. He's an interested party, and you want the transfer registered as quickly as possible. You've given him a discount maybe because he's asked for it, and you don't want to lose the transfer. Yeah, these are sort of things that you will encounter in a conveyancing. I had a situation fairly recently where I was asked to do the transfer for the purchaser, who was my client, and the seller agreed that we could do the transfer, knowing that we were actually the purchaser's attorneys. The purchaser paid a deposit of 300,000 Rand, but then reneged on the sale agreement. Didn't come up with the balance of the purchase price. It wasn't subject to a bond, and he was in breach. So the seller then instructed us to put the purchaser on terms and cancel the sale. Okay, so we were now in a situation where there was a conflict of interest between the seller and the purchaser. We instructed the seller to instruct his own attorney, and we instructed the purchaser that we could no longer act for him, and we kept the money in trust on the basis that we would release the deposit to whoever, once they had reached agreement or failing agreement, court order. And as it turned out, they reached agreement whereby they cancelled the sale. The seller kept 150 and the purchaser took back 150 and the seller was able to resell the property. If you get yourself into a conflict of interest situation, you need to probably withdraw and let the parties sort their issues out. Another issue, another important, while we're dealing with sale agreements, because this has come up with us, if you're selling a property to a trust, you must ensure that you get a resolution signed by the trustees authorizing the purchase of that property. Okay, because in terms of the Alienation of Land Act, if you do not get a resolution signed by all the trustees, let's say you get one trustee who signs the sale agreement, the offer to purchase, but he doesn't have an authorizing resolution, that sale agreement is not binding. Okay, there's case law that says every trustee must authorize the purchase. Okay, so be very careful when you're selling to a trust to make sure you have an authorizing resolution. Okay, all right, so your next most important document that you get is your deed of transfer. Okay, the title deed showing your client as the registered owner. Now, if he has a mortgage bond over the property, the title deed will be sitting with the bank that has the mortgage bond over the property as additional security. Okay, so you'll have to write to the bank once you've got the bond account number from the seller, requesting the settlement figure, what amount is required to cancel the existing bond, and asking them to let you have the title deed so that you can prepare the new deed. Okay, so you have your existing title deed, and from that existing title deed, you will then draft your new deed, and we call that the draft deed. Your new deed and your deed of sale are the two documents that you will make reference to enable you to draw your new deed of transfer in the name of the purchaser, which will be lodged for registration at the deeds office. Now, I don't want to go into this because that's Mareka is going to deal with this on Wednesday. She's going to take you through a deed of transfer and analyze it for you in detail. And that's a very important foundation or building block. You must follow the analysis of a deed of transfer, Form E, from the preparation clause right through to the execution clause. This is where the drafting is so important, guys. I can't emphasize this. How you describe the transferor in a deed of transfer, how you describe the transferee, the causa, how will you draft the causa in a deed of transfer, the property description, the conditions clause, all of this, Mareka will be dealing with you in great detail, and it's an important building block. Once you've got the hang of that, you will be able to build on that without too much trouble. Just before I leave on sale agreements, the Alienation of Land Act, I think Mareka will deal with that again in also more detail, but just remember there's a couple of clauses in the Alienation of Land Act affecting a sale agreement. If the property is under 250,000 Rand, there is a cooling off clause. No, it's very unlikely that a property that you sell, immovable property, will be less than 250. But bear in mind, section, I think it's 29 of the Alienation of Land Act refers to a cooling off clause. Okay, you'll come across this again in the exam. It could be a question in part 1, short questions. Discuss the cooling off clause in the Alienation of Land Act. So you will be dealing with the Alienation of Land Act, particularly as it relates to contracts of sale, sales of land on installments. It's an important act as part of the syllabus. So we'll come back to that. But remember with the Alienation of Land Act and the cooling off clause. We've dealt with a sale agreement as it relates to mainly freehold. The same rules apply when you come to sectional title. Now, sectional title is a chapter all on its own, and you'll deal with the sale agreement there. There are a couple of additional clauses that you will insert in your sectional title agreement. So estate agents Pam Golding, for example, will have a standard offer to purchase for a freehold property, and they'll have a standard offer to purchase for a sectional title, because there's certain additional clauses that you'll put in a sectional title sale agreement. For example, is there a right, does the developer have a right to extend the scheme, etc. So those go into sectional title. I won't deal with them here because I like to follow the format, so you'll deal with this all when you come to sectional title. Okay, so that's a sale agreement. You've got your deed search, you've got your sale agreement signed and accepted, and you've opened your file. Incidentally, when you open your file, I'll send you a file cover that we use in our firm, but each firm will have their own system of managing a transaction. Remember, you've got the seller who wants his property sold. You've got the purchaser who's paid you his purchase price. You've got the agent on your back for his estate agent's commission. So they're going to be on your back virtually every day asking you, how's the transfer going? You need to have your transfer cover with a summary of the transaction. Okay, so that you don't, every time you get a phone call, you don't flip through the file to find out where you are. Have you got the rates clearance certificate? Have you got the guarantee? Have the costs been paid? You can see from your front cover. It's very important from a practical point of view that you manage your transaction efficiently. And the way to do that is to have everything summarized on your file cover. We have gone to the extent where we have file covers pre-printed with all the information that we populate once we've got the offer to purchase from the estate agent. That is, details of the seller, their contact details, details of the purchaser, their contact details, the purchase price, date of occupation, when the guarantees are due, when the deposit is due, has the rate certificate of compliance been provided, have we received our transfer costs, yes or no, have we received a transfer duty receipt, yes or no, rates, figures. So that's an important tool to enable you to manage the transaction as a transferring attorney, so that the wheels don't come off. Quite important, and I'll share that with you. My email address once again is mike@hglaw.co.za. If you send me your email address, in fact, don't send it to me. Send it to my secretary. Send it to Sue, S-U-E, @hglaw.co.za, and she will populate a conveyancing group, conveyancing 2 group, and she will respond to all your requests for the examples that we've discussed in this lecture today, and anything else that you may require, and I'll circulate it. It's not something that Mareka likes, because she likes everything to be populated on eLeader. As you can see, I'd battle sharing docs. I'll be up to speed next time. But I'm old school, and in the past I've always emailed examples to everyone so that they've got them, and you'll build up a file of examples, some of which you have to memorize, some of which will help you understand conveyancing, and you'll take it from there. So hopefully this introduction has been helpful. It's just basically an introduction. You're going to be delving into conveyancing in big time on Wednesday. I think Mareka will need about 5 or 6, or however many. Then Nolufefe might take over on estate transfers or something like that. I'll pop in now and again on some other topics as and when required. So I'll leave you now. It's 11 o'clock. Guys, it's early, but it was just an introduction. I'm not going to go into the analysis of a deed of transfer because I want Mareka to deal with that on Wednesday. And I don't want you to have information overload at this point in time. Okay, you're going to get information overload later. Thanks, guys. Please feel free to be in touch. Good luck, and do the work. Memorize the documents, and keep in touch. Interact with all of us so that you understand everything. Don't be shy to ask questions. and get the answers to that, and hopefully do the assignments, and you'll all get through this exam. I promise you, it's not a difficult exam. And yes, I think there is a WhatsApp group, or there will be a WhatsApp group. Mareka normally attends to that. I'll make sure that we get a WhatsApp group. There will be pre-assessment questions. Yeah, I think you've got to fill in those pre-assessments so that we can see how we gauge it. And what else? I think that's about it. We'll prepare you for this exam. Please believe me, no worries. And I used to be an examiner for the conveyancing on the examination panel. I know the examiners. I will liaise with them. They won't give me the question paper, obviously, but they will give me an indication of what you need to focus on. And that will be towards the end of the course. And we will, obviously, my object is to prepare you for the conveyancing exam. Are we allowed to write notes in our deeds? Do we take in? Yeah, I think you can. You can write notes, I'm sure. Other questions? Can you take in a calculator to calculate the transfer duty? I don't think so. I don't think you're allowed to take in your cell phones. You might be able to take in a calculator, because sometimes the question does come up, calculate the transfer duty payable. Okay. Anyway, but don't worry about the exam right now. Just worry about understanding conveyancing and what you need to know. It's a drafting exam. Just one tip before I go. The description of parties, the transfer rule. You'll describe them by reference to their full names, ID number, marital status. If you memorize how you describe a transferor and a transferee and the property, you're going to get points for this exam. It's not a difficult exam to pass, but we'll hand over to Mareka and carry on from there. I mean, if Mareka's on board, no, I think she left. She could take you on from now, but hey, it's the first lecture. It's 11:15. We're not, as I say, ever going to go on to 1 o'clock. So I'm going to stop now, let you go on, enjoy your weekend, and I won't see you on Wednesday. And good luck. Enjoy. Have fun. Thanks.